up my screen. There we go. Hey, ang Kamalia, hoyet, tistel tawito anotet. So, hello, my friends. It's good to see you here today. Or my name is Red Eagle, and it's good to have you here today. We'll be talking about tribal confidentiality. A little bit about myself. Some of you have been in tune with some of the previous presentations, so you know me quite well. But my name is Ethan. My family name is Lawton. My native name is Kawakbuk, but Red Eagle is a lot easier to say. And I'm originally from up in Alaska. I was born in Anchorage at the tribal clinic there. I come from 4 different nations. One of the nations I come from is Inupiaq. We're up in the northwestern region of Alaska, and we're part under the Inuit umbrella. And my family village is Kotzebue. It's a small village up in the Arctic Circle and have a lot of family up there. I'm also a Quarter Sioux, part of the Lakota, and we're located in the Dakotas, and we're part of the 7 Council Fire. I'm also a Quarter Navajo, specifically the Bitterwater Clan. We're located in the Four Corners region, and we have renamed ourselves Dene, although Navajo is most common known. It's the Apache given name, meaning sheep stealer. And Dene is in our own language, meaning the people. I'm also a Quarter Tohono-O'odham. I'm an enrolled member of Tohono-O'odham Nation. We're located in southern Arizona, and my family village down there. And we used to be formerly known as Papago. Papago is an Apache given name, meaning cotton pickers. And we renamed ourselves in our own language, Tohono-O'odham, meaning people of the desert or desert dwellers. A little bit of background. I know I look young, but it's just the native genes. I've been working cross-culturally as an intercultural specialist for about 15 years now, and I study cultures and I study people, and that's mainly my realm of expertise. And I've started focusing more on tribal, and I've been a tribal liaison for about 10 years now. And I'm relatively new to the planning realm. I've been with SHN for about 6 years now, and 6 years within the planning realm. In that course of time, I've worked professionally with over 50 tribal governments and have personally traveled to well over 100 reservations throughout the states and have interacted with many, many tribal members from different tribes. So as Bob mentioned earlier, this is the tail end of our series, and I thank you if you've been a part of all of them. If you haven't, welcome. And we started off with tribal meeting cross-culturally with tribes, ethics and etiquette. And then we also covered tribal sovereignty and tribal governments. And then we also covered tribal consultation and tribal lands. And last time I presented here on this platform, it was covering tribal cultural resources and mitigations. We'll be closing out this 6-part series on tribal confidentiality. I laid it out like this because it builds on itself, and you get the most out of it by going through it in this order. But tribal confidentiality. So I have a few disclaimers. One is I'm not speaking on behalf of all the tribes. I may speak generally on we or different things like that, but it's just for educational purposes. Second disclaimer is although I will be talking about legal stuff, this is not intended as legal advice. If you have legal counsel, I encourage you to talk with them about legal matters. And if you don't, or if you need additional legal counsel, I recommend California Indian Legal Services. They're throughout the state. I just listed an office close to where I am located. So the purpose of the presentation is this. I redacted it as part of humor. I hope you see it as funny, but the purpose of the presentation is to provide a better understanding about tribal confidentiality and improving communications and how it involves publications and really honing in on building and maintaining trust and how that fits into the relationship. I changed the description a little bit to really focus on the different needs, levels, and areas and examples of confidentiality. So those are some things that I will be mainly focusing on. And then question and answer will follow the presentation. So here is the outline of what I will cover. We already completed the introduction, but the flow is the different needs for confidentiality and the different levels of confidentiality and the different areas of confidentiality. And then I'll close out the presentation by different examples and best practices, and then question and answers. So we'll move into the different needs for confidentiality. There are so many different needs, and I just kind of focused on the generalized ones on the need for confidentiality. One is the protection. If you remember my tribal lands presentation, I showed this kind of video clip that showed how the lands have changed and how the colonies and states further moved west. But here's a generalized image to show kind of the tribal lands before the United States and then after current. And we see that reservations were created to protect the migration west and from conflict and intrusion. And so this land was kind of given to ensure that the protection of the people and the culture and everything that comes with that. And that overflows into confidentiality. Part of why confidentiality is needed is to continue to protect that culture and the people and the different things that are involved in that with that land exchange and everything that comes with that. So there is a huge need in regards to protection. Then one we're quite familiar with is environmental impacts. The need for confidentiality is to help protect the impacts. Sometimes in projects, there's a lot of incompatibility or other kind of impacts regarding lands, resources, graves, traditional cultural properties. All of these I'll get more into in a moment. But there's a need to kind of protect that. So there's protect the people, there's protect the impacts. Then there's protecting in regards to significance. So in tribes, well, any culture, we all have taboos, regardless of what culture we're in. And in tribal culture, there's taboos in sharing too much information. That's why I'm kind of sharing broad information today and not too specific, but it just goes to show that Native Americans prize cultural information, and it's a taboo to share too much. And so the need for confidentiality protects that. And there are venues which that can happen, which I covered in consultation on how that can be shared, but still protected. And I'll share a little bit more about that in a moment. But the need for confidentiality helps cover and address the taboo of disclosing information to outsiders. Outsiders being people not in that expert field within the tribe, then those outside of the tribe, and then those outside of any tribe. There's kind of different levels to that, but it protects the taboos. Then another need for confidentiality is assurance. there has been so much lack of trust. The federal government has made treaties with the tribes and has broken every single one of the treaties, and some of them multiple times. And so that's why there's a lack of distrust among tribes. And so the need for confidentiality shows that they can share and disclose information while still being protected and managed in a sensitive way. And that helps address the lack of trust, and it should help build and maintain trust when there is that disclosure of information. So that's another need for confidentiality. And finally, there's the need for confidentiality because tribes are based on a verbal and oral tradition. I know in the Western world, documentation is everything. Everything needs to be written, signed, have a witness, that type of thing. And so in tribal cultures, it's more verbal and oral tradition. And words, as a result, words are so powerful. They're even spiritual in nature, because words can bring change into this physical environment that we're in, and that's why it has so much power and significance. And words are sacred. They're rare. Most people who are wise don't talk much, and when they do talk, everyone listens because they are sharing like that wisdom that they have, because they understand that words are sacred and aren't to be flown around recklessly. And words are a reflection of oneself. So who we are as a character, who we are, like our heart and our mind, our words are a reflection of that, because it comes from that source. And so again, that's why words are just so powerful. And when words are exchanged and information is disclosed, that expresses a need for confidentiality. So I just wanted to share some of the needs for why there is a need for confidentiality. And again, it's not exhaustive, but I just wanted to provide a better understanding. And then now we'll dive into the different levels of confidentiality. I've studied so many different facets of tribes and different things, and I've come up with this type of structure for confidentiality. So I think there are 3 different classifications for confidentiality when it comes to tribes. I think there is proper, which confidentiality proper is what I'm calling it. And this is kind of the legal basis, the legal protections around confidentiality. And as we all know, the law is the most minimal kind of expectation and of anything. The law is the minimum. And so the legal protections around confidentiality I've labeled as proper. As we exceed the minimum, I think we get into 2 different realms, private and privilege, and I'll dive more into each of these. But private I consider more of a moral issue, and privilege as more of an ethic issue. Again, these are just generalized buckets that I've kind of see them as. And so just as I talked about consultation, how there's so many different venues and definitions of consultation, I believe it to be the case with confidentiality as well. When someone is talking about confidentiality, it's important to understand which realm they're talking about. And I'll dive into each of these, starting with theology or confidentiality proper. Regarding the legal sense, again, it's the minimum. It's the responsibility and obligation according to the law. And there's so many different laws on confidentiality, and I'm not going to dive too deep into these because there are already experts, and I'm more focusing on kind of the broad sense. But these statutory obligations are specific and they're outlined in so many of these different acts and laws, and they apply to so many different areas, and I'll cover some of them in the different areas of confidentiality in kind of a broad stroke. But again, the confidentiality proper legal is the bare minimum. As we exceed the minimum, we get into private moral, and this is in the absence of legal requirements. This is where we get more into like the professional obligation. It involves more of the respect of the privacy. And I kind of view this more in this as a reflection on the self or the agency. So where confidentiality proper is more of a reflection on the law, confidentiality private is a reflection on you and your agency or whoever you're representing. And then we shift to confidentiality privilege. And I see this more as an ethical issue, where it may not be explicitly confidential, but it's still sensitive information, kind of like a secret. If you disclose, sensitive information like a secret to a friend or family member, and they share that information with someone else, there's no law against it, and there's no repercussions for them breaking that, other than it may cause a rift between you and them in a relationship, or it may break that relationship altogether. That kind of sensitive information I would place in this bucket. And because it's the individual to control that information, it's about autonomy themselves. And this affects the faithfulness and the trust, and it can build it and maintain it, or if it's broken, it can destroy it. And again, this exceeds the bare minimum legal requirements. And that's why I listed it here as important. And just as the different levels are reflections of different things, I would place privilege and ethical as a reflection on the other party. How do you value and prioritize the other party involved? And I would say that's a reflection of this confidential privilege ethical bucket. So we see that there's these different buckets and how they're a reflection in different levels and how they focus on different areas. So with that, I'll move into different areas specifically on confidentiality. And these 4 areas I want to briefly dive into is confidentiality when it comes to consultation, when it comes to culturally significant resources, and when it comes to sacred sites, places, and landscapes. And then I'll have a little short note on other. So as I mentioned in the confidentiality presentation, there's numerous different consultations. I only included just a few here. But there are different confidentiality protections within that consultation process. And they're different and with each realm. And as you move further down the rung from federal to state to county, city, it kind of becomes a little bit less and less. The most strict confidentiality we see at the federal level. And most of the protections are kind of around there. And I think it's only a matter of time before it slowly trickles down more and more to the local level. And we've been seeing that more and more in the past decade or so. So there's different areas of confidentiality within the consultation process. In regards to culturally significant resources, there are kind of 3 different subsets to this. Archaeological sites, cultural resources inventory and reports, and environmental documents. Starting with archaeological sites, disclosure of archaeological site information is exempt from disclosure, and there's a code there. So any kind of site can be withheld from disclosure because it's protected confidentiality. And this covers, based on the consultation, based on the values of the tribe, but there is protection on archaeological sites from disclosure. And then the lead agency may exchange information confidentially with other public agencies that are involved in that review process. So we see that there may be different entities involved, and that information can be shared internally within that group, as long as it's shared confidentially. Not only that, but moving on to cultural resources, inventory and reports, it's to be maintained by the lead agency under a separate cover. So there are confidential protections around cultural resource and inventories and reports, and how that is to be maintained separate. There's tons of best practices, kind of labeling different folders, and even kind of locking it with password, having one person maintain the flow. There's so many different best practices when it comes to maintaining confidential documents, including inventories and reports. Also, these inventory and reports should not be available to the public. And you can include kind of like the cover sheet and express how it's confidential. And it can be accessed by those who are qualified and who are approved. But the general public, cultural resource inventories and reports are not available. And this is confidential. However, information from the inventory and reports can be included in an appendix, in a confidential appendix. So again, it just goes to show that it's closed to the public, but you can gain access, again, if you're qualified and approved, you can have access to it. Regarding environmental documents, information about the location, about any culturally significant resource is exempt and should not be included in any environmental documents. And they're exempt from Public Record Acts and Freedom of Information Act. And so it just goes to show how far the confidentiality goes in regards to legal matters within environmental documents. So no location information is to be included. However, the lead agency may describe in general terms. So without being specific, they can include general terms within the environmental documents. This is so the public is informed and can make an informed decision while still protecting confidentiality. And the line can be pretty vague when it comes to describing culturally significant resources in general terms in environmental documents. But it just goes to show that you can speak generally to it while still maintaining confidentiality. And information submitted by the tribe may be included or may not be included or disclosed to the public without prior written consent. So if a tribe submits information to you or a lead agency, that information is confidential and can't be disclosed to the public without consent by the tribe, written consent, when it comes to environmental documents. And this protection extends to the tribe's comment letter. So when a tribe submits a comment letter regarding the environmental document, that's confidential. As I mentioned before, however, the lead agency can summarize the tribal comment letter in a general, vague way while still maintaining confidentiality. So it applies to information that the tribe submits, and it applies to the comment letter. However, this doesn't apply to a public comment. So in a public meeting, if a tribe were to share, that's on a public platform. And I'll mention that more in a moment. But so there's so much that revolves around environmental documents. And now shifting gears to sacred sites and places and landscapes. Sometimes these are used interchangeably, and sometimes they're definitely not the same. And I included an example here just to really drive home this point. So a burial ground is a sacred site. When a Native American is buried, it is sacred. That's their resting place. I mean, this applies to so many different other cultures on how cemeteries are like memorial grounds, or how we say rest in peace, because we know that that's their final resting place. But in Native American culture, it's significant in multiple ways, not just because that's their final resting place, but it's a sacred site. And then we get into, the hill where that burial ground is, and that hill is a sacred place. And it could be a sacred place independent of the burial ground. So they could feed off of each other. For an example, the burial ground may be placed there because it's a sacred place, or it's a sacred place because the burial grounds are there, or it could be both. And we see how it's independent, but they feed into each other. And then the hill may be a part of a mountain range that is the sacred landscape. So we see how all of these can be independently sacred and still interconnected as a whole, and how all three of these are sacred and each of them independently are sacred, and how they're woven in together is sacred as well. And so it's a brief example of how cultural sites, places, and landscapes differ, and how they are connected in regards to sacredness, and how they are considered culturally significant and may be protected by confidentiality. Graves and cemeteries are definitely protected by confidentiality and are exempt from any kind of disclosure. And this is for numerous reasons, some which I stated before. Another reason which I haven't stated is oftentimes when Native Americans are buried, we're buried with our most prized possessions. That includes our traditional outfit, our regalia, some maybe prized jewelry, and many of our other favorite things. And so grave robbery was a huge issue in the past, because people would dig up graves and take those prized possessions. And as a result, any kind of location about graves and cemeteries is exempt from disclosure for numerous reasons, including the one that I just stated about how so many valuable stuff is buried with the individual. And again, that's generally speaking, that's not always the case, but it's pretty common. Shifting gears into other, I mentioned information that's disclosed in public meetings, and this kind of falls into this bucket. Any information that is already publicly available, whether through a book or a news article or any kind of other public platform, can be disclosed in the environmental review process. So if it's already public information, then it could be shared publicly because it's already public. So this is where the confidentiality doesn't quite apply, because it's already public. And so it's something that you have to be aware of when disclosing sensitive information. Another I wanted to include is the project applicant or lead agency is responsible for keeping this information confidential. So as you intake tribally submitted information or intake tribal comment letters, it's the duty and responsibility to keep that information confidential unless the tribe consents to a disclosure in writing, unless there's some kind of agreement. Sometimes it's in the form of an MOU, Memorandum of Understanding. And this is to prevent many of the things I've already shared, including looting, vandalism, damage to that cultural resource, and it's to protect it. So it's something else to keep in mind. So now I'll talk about the different examples. I talked about the different levels, the different areas, the different needs. And now I'll talk about different examples. One example of confidentiality is this Shasta Dam. They wanted to increase the dam, which would increase, the reservoir. And there was an inundation of sacred grounds of a tribe that would be inundated if the dam were to increase. And so the tribe shared this concern and this resource. However, they didn't disclose, the location of it, other than it would be inundated. And this was to protect the sacred grounds and from being disturbed or vandalized or damaged or destroyed by visitors and by inundation. So they disclosed the sacredness, but they did not disclose the location. Another example is in Arizona, there was an expansion of a ski area that was rejected, turned down, because the mountain was considered sacred by the tribe. And although they disclosed that it was sacred, they didn't fully disclose how the expansion of the ski resort would impact the sacredness. And so there are numerous things behind that, but again, all of that is confidential. However, it boiled down to the sacredness of the mountain, sacredness of the place and the landscape, and different things like that. Another one, on the flip side, it's public knowledge that any kind of human waste, any kind of human remains is not to be on any kind of sacred place within the Navajo Nation. It's part of tribal law. So it's common, it's public, it's common knowledge, it's public knowledge. And when a ski resort used reclaimed sewage wastewater to make snow, the tribe went against this because it went against this value and culture, and even against, tribal law that you can't put human waste in a sacred place. It'd be like someone smearing waste on a well-liked, synagogue or chapel or different things like that. It's just something you don't do. And so the tribe went against this, and it wasn't quite confidential because it was public knowledge. And, so it just goes to show that when it's public, that information can be disclosed. Kind of a more local one up here in Northern California was logging roads. There's numerous logging roads that are created and maintained throughout our wilderness, and there were several local tribes that went against the National Park Service and some routes of the logging roads because they went through some sacred areas. Again, some of that information wasn't disclosed on why they're sacred. It could be burial grounds, it could be religious, it could be many other different reasons. But it just goes to show how the confidentiality can disclose a general nature, that it's sacred, without disclosing specific. Another example of confidentiality applies to teak. It's more of a growing and growing field. Well, more of a growing respected field. The field has always been there and it's always been growing, but it's being recognized more and more by non-tribal people. And it's traditional ecological knowledge, and it revolves around how the tribe or their culture kind of interacts with the environment in a traditional manner. And some of that is protected in regards to how they do it, or maybe even why they do it. So it's an example of confidentiality in regards to intellectual property in a sense. And the state, I think, is getting more and more aware and creating space for teak to take place. One realm that we're really seeing that is in traditional burning practices. And I think it'll be a matter of time before even more different fields become more and more practice in regards to teak. I think this is my last example, but of confidentiality. Tribes have struggled and have fought against forced assimilation over the past centuries, and practicing culture was criminalized, and religious practices were forced down, and there was a lot of assimilation away from all of that and mandated adoption. And so that's why there's so much protection, so much concern, so much revolving around confidentiality about what practices are remaining or what practices are being revived by the tribe or by the tribal people. And so it just goes to show that why there's a huge need for confidentiality. And the example applies to practices as well. Oh, I think this is my last example. The United Nations made a declaration which the US adopted, and so many other countries adopted, and so many countries were involved in creating this Declaration of Rights of Indigenous Peoples. And this extends to the right to maintain and protect and develop cultural, intellectual, religious, spiritual, any kind of information, and the right to privacy. And this extends to confidentiality. And for the indigenous people, for the right to access and re-access the culture. And so the need for confidentiality. So before I get into best practices of confidentiality, I want to mention, access to CRIS and access to the Native American Heritage Commission and access to SHPO and many different other fields or realms. The record keeping is shifting, and it's always been the case and the goal. For an example, the BIA and tribes, we're seeing this transition take place of the federal entity taking on all the responsibility and tribes taking on some responsibility. And we're seeing this shift happen to where tribes are becoming more and more capable of doing things themselves, and that shrinks the BIA responsibility and duties as the tribes are taking more on and on and on. And that applies to confidential records as well. I think we're seeing the shift from state and federal maintained records, and tribes are beginning to have more and more of their records maintaining themselves internally. And so it just goes to show that even if there's no results in the state or federal records, it does not mean there's no findings within the tribal records. And it just goes to show the need for tribes maintaining their own records confidentially. And so with that, I'll close on best practices for confidentiality. I only have one slide, and I condensed it as simply as possible and how it ties in everything we've covered already. So one, the bare minimum is the legal realm. Know and understand the laws, and especially the definitions. There are so many different definitions out there. And just as I mentioned before, when you mention confidentiality, it's good to understand what specifically are we talking about. So knowing the law and definitions is the bare minimum. Then we shift to moral. Know your personal and your agency's values and priorities when it comes to protecting information. And that goes both ways, working with tribes and protecting information with the public. You may be caught in the middle of disclosing information and protecting information. So know your personal and agency's values and priorities when it comes to confidentiality. And then there's know the tribe's values and priorities when it comes to confidentiality. The tribe may ask for something to be confidential. And so understanding the bare minimum, understanding your agencies, and understanding the tribes. And these may be far different, which is why I included the fourth, and that's to present, to listen, to discuss, and then to agree on what is to be confidential, what is not, what are the procedures, different things like that. It's important to be on the same page when it comes to confidentiality. And this may be helping either side or both sides understand. And this may look like a memorandum of understanding. It may look like, some kind of other agreement on maintaining confidentiality. So this is the best practice. And again, this filters down in so many different ways, but I just wanted to be more general in nature. So with that, I think we'll move into questions and answers. My name and email and phone numbers there for you. Feel free to submit questions in the Q&A or the chat, or ask me personally. But I think we have like 10 minutes for questions, and we can end the recording if we want, to kind of maintain confidentiality with your questions. But with that, thank you for being a part of the presentation. Thank you for listening. And we'll see if there's any questions.
Yeah, please use the question answer thing on the bottom of your screen. Maybe it's on top. We do have one question. So question, is the name of tribes communicated with considered confidentiality? That's the name.
The name of the tribe would be public information because it'd be listed in numerous places. It'd be listed on the tribe's website, typically, which is public domain. They're listed on the federal registry, which would be public domain. However, the tribes may have their own name for themselves that may differ from that, and that could be considered culturally significant, and it'd be something worth discussing with that tribe if it is confidential. However, generally speaking, the name is public information. And just like with my 2 tribes that I mentioned, 2 of my 4 tribes, there has been a process of a name change. And so that may be in process as well. But generally speaking, no, it's pretty public information.
So one of the things you and I talked a little bit about was just, and you kind of concluded with it, is if there's any doubt, feel free to reach out to the tribe and see what is confidential and what can be shared. As a good practice.
Yes, when in doubt, ask.
In your experience, what types of general project types have proven challenging in maintaining confidentiality?
I would say maintaining confidentiality above the minimum requirements of the law has been the most difficult realm. Tribes tend to think that everything they disclose is confidential, and to a public agency or local government, they have, you know, a local duty to maintain records. And so that gray area that I mentioned of moral and ethical is kind of that exceed the law, is kind of a huge area. Non-formal consultation would be an area of a confusion regarding confidentiality. And again, that's why I say to know the law, to know your agencies or local government priorities and values, and the tribes, and then agreeing on it. I think there will always be differences, which is why it's good to share and discuss and listen and agree on those differences. But yeah, I know that's a general answer, but that's my experience so far without disclosing specifics.
I would probably guess that the smaller the site, the less you can really talk about it. The larger the area that's discussed, the more general you can talk. Might be an issue. I have noticed that whether as a consultant, whether I go to the county and ask for a file that might be 5 or 6 years old, or even our own company is, you know, we can keep these reports out of the public, but then all of a sudden, 5 years later, you look at the file and there's this, you know, it's not clearly identified. And so confidential information could be released to the public inadvertently by not keeping it in a separate file or labeling it as such. So, I have another question. Or here's an example. We have encountered situations where multiple tribes have a historic presence at a particular project site. And in consultation process, one tribe requests that the lead agency refrain from consultation with other tribes on the basis of confidentiality concerns. When, if ever, would this be appropriate? What resources should lead agencies turn to in these circumstances?
Great question. I'll break this into 2, maybe 3 parts. First being the consultation process. So by law, whatever project site, you reach out to the Native American Heritage Commission. They give you a list of tribes that you are to reach out to by law for consultation invite. So one tribe requesting to not consult with the other tribes would be in opposition of state law. However, the different realm I want to address is confidentiality. So although you're required to consult with all the tribes, you can consult with them individually as opposed to collectively. That may be a better or a best practice to implement. But in regards to confidentiality, as the lead agency, you don't have to disclose that other tribes cultural resource or anything like that, you, as part of the consultation process, you disclose your project, and then the tribe disclose if they have an impact based on the description of the project. And then you discuss mitigations and agree on it and move forward. So even consulting with other tribes, there's no breach in confidentiality because you're not sharing any cultural resources. You're giving the tribes opportunity to share if they have any concerns on the impacts. Some resources for these would be the consultation requirements and the law, the confidentiality clauses with those consultations, whether it be through NEPA Section 106 or CEQA AB 52 or anything like that. But I would break those up into different consultation process, confidentiality, and then cultural resources.
Okay, great. No more other questions. I have one though. You mentioned a couple times, I don't know if you're prepared to answer this, but certain qualified people can review this information. Is, what is that qualification? Is that listed anywhere specifically?
Yeah, I can't disclose that information. No, I'm just kidding. Yeah, there's a qualification process, like a standard minimum in regards to the Department of Interior sets who is qualified to access, this confidential information. And they break it up into historic and prehistoric. And there's different qualifications for those different levels. Some of it includes your educational background. Some of it includes your hours of experience. Some of it also includes different credentials. And so based on those qualifications, you can access confidential information through an approved process, whether that be through the tribe, through their approval process, whether that be through the Native American Heritage Commission and their approval process, whether it's through CRIS or any kind of other state record keeping and through their process.
Okay, I do have a question about monitors. So if we engage tribal monitors to mitigate potential impacts on tribal cultural resources, would the best practice be to retain monitors from each individual tribe that requests a monitor?
That would be discussed through the consultation process. It is not uncommon for there to be multiple tribal monitors on one project site. I think there was one project where there was 3 different tribal monitors present monitoring the site because it crossed the boundaries. It was on the boundary of 2 historical tribes and 1 Indian Reorganization Act tribe, and all 3 had concerns of cultural resources there. I don't know what they would do if they found something. I think it'd be for the 3 of them to hash out, but it has been done where multiple tribal monitors have been on one project site location.
Especially with tribal cultural resources, the lands could have been used differently by different folks and have a different focus or issue.
Correct, because there could be a situation where the land, that site has exchanged tribal territory, or it's changed over time. So there could be an artifact kind of historic and to one tribe and prehistoric to another tribe. So there can be a situation where that is the case.
Great. Well, we don't have any more questions and we got 1 minute left, but I just want to say thank you. You did put your information on here, and thank you everyone for attending, and we'll maybe see you next month. Thank you, Ethan.
All right.